Welcome to the deep dive. We are tackling a legal question today that is, well, as complex as it is visceral. When does owning a dangerous animal cross the line from a tragic civil matter into a criminal prosecution? This isn't just about simple neglect. It is entirely about what the owner subjectively knew. We are diving into the landmark California case, Berry v. Superior Court, to really find the legal boundary between accident and crime.
That's right. And for you, the learner, the mission here is crucial. It's to isolate the specific factual evidence courts use to prove that all-important element, subjective knowledge. Because frankly, without that, criminal liability just doesn't stick. We are going to define the legal rule of foreseeability, break down the B. Berry case piece by piece, and then synthesize the key evidence markers into an actionable checklist for identifying criminal intent.
Okay, let's unpack this then. Let's start with the core hurdle. If you want to hold an individual criminally responsible for something an animal did, what general legal standard must the prosecution meet regarding the owner's state of mind? And maybe more critically, what happens if the animal has never actually hurt anyone before? Doesn't that sort of cut against criminal liability?
That tension is exactly the legal challenge. The general rule, well, it dictates that criminal liability requires proving the defendant acted with a requisite mental state. Here, that usually means showing subjective knowledge of the extreme risk posed by the animal, or, alternatively, that the risk was so obvious and ignored that it constitutes gross negligence or recklessness. Just owning a certain breed, that's absolutely insufficient. The court has to find that the owner not only knew the risk existed, but could or should have foreseen the specific type of lethal harm that eventually resulted.
But wait, how do you actually prove someone knew their dog was a ticking time bomb if, the dog had ostensibly been well-behaved right up until the tragedy? Doesn't the defense almost always argue the attack was a total surprise?
Oh, absolutely. That is the defense's standard move almost every time. And that's precisely why the Berry case is so instructive. It shows us that a court doesn't just look at the animal's past actions or lack thereof. They look at the owner's preparations. They look at the owner's own assessment of the danger revealed through their actions.
That makes perfect sense. Okay, let's test this rule immediately. Let's dive right into the details. Let's analyze Berry v. Superior Court. First, what are the legally dispositive facts? What set the stage for this tragedy involving Michael Patrick Berry and his pit bull, Willie?
All right. So Berry owned Willie, a pit bull. Willie tragically killed 2-year-old James Soto, a child who lived with his family on the same property lot. And as you pointed out, this is key. There was no evidence Willie had ever attacked a human before. That's the defense's strongest point, naturally. But the prosecution countered with, frankly, a mountain of evidence showing Berry did know the threat. And it starts with how Willie was acquired.
Right. This is where the evidence gets really fascinating and disturbing. Tell us about the acquisition and what the breeder told Berry.
Okay, so Berry purchased Willie from a known fighting dog breeder. And this breeder wasn't subtle about the dog's nature. Not at all. They explicitly informed Berry of Willie's fighting abilities, his gameness, which means that intense tenacity in a fight, his endurance or wind, and critically, his exceptionally hard bite. And the breeder delivered a chilling, very specific warning. They said that in a dog fight, a dog won't go an hour with Willie and live. Now, this wasn't some standard pet warning, right? This was basically an instruction manual for a lethal weapon.
Wow. So Berry had specific, explicit, high-level knowledge of the animal's lethal capacity straight from the source. But the evidence didn't stop there. It continued once police searched the home, proving Berry was actively maintaining that capacity.
Precisely. The search, well, it really turned the case from just a tragedy into a potential crime. Police found underground publications about dogfighting. They found a detailed training pamphlet called the 42-Day Keep.
42-Day Keep, what's that?
It outlined these really intensive 6-week conditioning procedures, basically how to prepare a dog for a match. They also found a treadmill, presumably used to increase the dog's endurance, and even photos of dogfights.
And then there's that piece of evidence we have to highlight, maybe the most unforgettable one, the break stick. What exactly is that, and why is its mere presence so damaging to the defense's claim of unpredictability?
The break stick. It's a tool specifically designed to pry open the jaws of a pit bull that is locked onto something during a fight. You can't just command them to let go. Its presence is, well, you could almost call it the ultimate admission of guilt regarding knowledge and intent. It proves the owner knew they possessed an animal that attacks with such ferocity and tenacity that it literally cannot be controlled by voice command once engaged. It's physical evidence that the owner was prepared for and, frankly, expected lethal, uncontrollable conflict.
That seems overwhelming. But, the defense always tries to find holes. I understand there was some conflicting testimony about warnings Barry might have given to the victim's family. How did the court weigh those supposed warnings?
Right. The conflicting warnings are actually quite important for proving the owner's own internal assessment of the danger. The victim's mother testified that Barry did tell her Willie was dangerous, but then he apparently assured her the dog was safe behind a 6-foot fence. That suggests maybe some level of mitigation or perhaps downplaying the risk. However, a police officer testified that the victim's father, Arthur Soto, had previously been warned directly by Barry to keep the kids away from the killer dog.
Killer dog, that's quite a phrase.
Exactly. Now, the father later denied Barry said that, but the fact that a police officer attested to Barry using the phrase killer dog, well, that significantly bolstered the prosecution's argument that Barry himself knew the severity of the threat Willie posed. He wasn't just calling him a guard dog.
And we also can't forget the context of where the dog was kept, which seems to further suggest an intent to use him as a deterrent against people, not just other animals.
Precisely. Willie was found tethered near 243 marijuana plants on the property. This strongly suggests that the dog wasn't just a family pet wandering around. It implied he was intentionally positioned and possibly conditioned as a guard dog, whose primary purpose was likely to deter human intrusion. This reinforces Barry's own assessment of the dog's danger level as a potential threat to people.
Okay, that totality of circumstantial evidence is really quite staggering. So, having laid out those facts, we must now turn to the core legal argument. Given that crucial lack of a prior attack on a human, what was the central legal issue facing the court?
The issue, boiled down, was whether the sheer weight of all this circumstantial evidence, specifically the defendant's detailed knowledge of Willie's inherent aggression, his trained fighting background, his lethal capabilities, was sufficient to support a criminal charge. A charge that requires a finding of foreseeability, even though there wasn't that prior history of attacking humans. Essentially, can evidence of lethal conditioning substitute for evidence of a prior bad act involving a person? That was the question.
And what was the fundamental rule the court applied in assessing whether this pile of circumstantial evidence was enough to overcome the defense's claim of unpredictability?
The rule the court applied is actually quite clear. An animal's lack of a prior aggressive history toward humans does not, by itself, negate an owner's criminal liability. That's the key. The owner can be held criminally liable if they possessed other concrete, specific knowledge demonstrating the animal was dangerous or, crucially, was specifically conditioned to be aggressive and lethal. That specific knowledge acts as the substitute for a prior bad act.
Okay, let's talk through the court's thinking then. What was the court's analysis? How did they connect Barry's deliberate actions, the training, the tools, the breeder's warnings, to the tragic death of the child?
The court's analysis really zeroed in on the intent behind the conditioning. They found the evidence overwhelming that Barry knew he possessed an instrument designed and conditioned for lethal combat. It wasn't just a strong dog, it was a fighting dog. They highlighted that Willie was selectively bred to be aggressive, tenacious, and importantly for foreseeability, to attack silently, without warning barks perhaps. The use of the treadmill, the 42-day keep pamphlet, and that absolutely damning break stick, all this proved the owner was actively maintaining a known legal fighting animal, not just caring for a pet.
So the argument that the attack was unpredictable just completely collapses, because the owner had systematically done everything possible to make the dog predictably lethal, essentially.
Precisely. And the court also addressed the defense's attempt to use testimony from an animal control officer, who initially called the attack unpredictable. The court noted that the officer's complete testimony actually affirmed that highly conditioned pit bulls like Willie, even without a prior history with humans, become highly aggressive under unpredictable situations. So the defense's own point inadvertently highlighted the known latent danger associated with this specific breed and training profile. They were basically arguing that an event happened that they knew was actually quite likely to happen under certain circumstances.
And based on this really profound analysis of the owner's state of mind, his knowledge, his preparations, what was the final conclusion of the court?
The court concluded that the extensive evidence regarding Barry's knowledge of the dog's breeding, its intense conditioning, and its aggressive disposition was sufficient for a grand jury to find probable cause. Probable cause that the death of the child was, in fact, a foreseeable and known risk from Barry's perspective. Therefore, the criminal charge against Barry involuntary manslaughter, I believe, was permitted to proceed to trial.
Okay, this is where it gets really interesting for the learner, I think. There's this visceral tension in the case, right? It relies entirely on the prosecution successfully arguing that a tool that breaks stick and the conditioning literature are somehow more powerful evidence of foresight than a clean record, a lack of prior incidents with humans. What does this case tell us fundamentally about how the law treats the creation and the active maintenance of a known danger?
It tells us the law values specific, deliberate action, or knowing inaction in the face of clear danger, over claims of passive ignorance or surprise. The evidence of preparation for lethal conflict, like owning a breakstick, essentially defeats any subsequent claim that the lethal outcome was unforeseen. Think of it this way. The breakstick wasn't found because Willie was just some normal, rambunctious dog. It was found because Willie was the kind of animal conditioned in such a way that the owner anticipated needing mechanical intervention to stop an attack. The court sees that breakstick and the training regimen not as random possessions, but as powerful forms of prior knowledge. Knowledge that the animal possessed a lethal capacity that Barry wasn't just aware of, but was actively honing. This is why, as a learner, you absolutely must look beyond the immediate tragic event and trace back the owner's investment in creating or maintaining the danger itself.
That specificity is absolutely crucial. We've demonstrated how the court used these markers, the tools, the breeder's warnings, the context of placement, the owner's own words, to establish criminal or at least the mental state required. Now let's synthesize this. Let's make it really practical. Based on our deep dive into the specific facts of Barry, how should you, the learner, approach an exam question to effectively issue spout criminal liability regarding dangerous property or animals, especially when there's no prior incident?
Right, you absolutely need to approach this methodically on an exam. Barry provides a fantastic, almost definitive step-by-step diagnostic checklist for proving criminal knowledge when prior harm is absent. Here it is. 1. Identify the instrument animal. First, establish that the property or animal is inherently dangerous or prone to aggression due to a specific breeding, design, or known characteristics. In Barry, it was clearly the fighting dog purchased specifically from a combat breeder. 2. Search for explicit prior warnings. Did the owner receive direct, specific warnings from the source, the breeder, seller, previous owners regarding lethal capabilities? Remember the breeder informing Barry of the exceptionally hard bait and that the dog would kill another dog in an hour. Look for that level of detail. 3. Search for owners' declarations of knowledge. Did the owner themselves warn others or refer to the animal using highly dangerous terms? That's where you look for proof, like the officer's testimony, that Barry referred to Willie as the killer dog. It shows his own assessment. 4. Evaluate preparation conditioning evidence. This is huge. Look for tools or practices proving the owner was actively maintaining or even enhancing the danger, not mitigating it. This is exactly where the fighting literature, the treadmill, and the absolute smoking gun, the breakstick, fit in. Evidence of active conditioning. 5. Assess context of placement. Was the animal placed in a highly accessible area or used specifically as a deterrent against people? This confirms the owner viewed it as a potential human threat. Think about Willie being tethered near the easily accessible marijuana plants. And finally, 6. Conclusion on foreseeability. If points 2 through 5 are substantially present, even without a prior human attack, a court is very likely to find the owner has subjective knowledge of the extreme risk. This makes the resulting harm foreseeable and satisfies the mental element required for criminal charges to proceed.
Okay, we've really unpacked how the law uses these very specific, concrete facts that break stick, the training regimen, the warnings from the breeder, the owner's own words, to cut right through the often heard claim of unpredictability. It's an incredibly clear path laid out by the court to proving knowledge. So, what does this all mean for you, the learner, moving forward from this deep dive?
I think the major lesson here, for you, is that when you're analyzing foreseeability in law, especially criminal foreseeability, the most powerful evidence often lies not just in what has happened before, but in what the defendant prepared for and what they demonstrably knew about the specific instrumentality involved, be it an animal or something else. The Barry case starkly shows that liability can rest heavily on the difference between just general knowledge of a breed's reputation, which might only lead to civil negligence, and specific, detailed knowledge of an individual animal's lethal capacity, coupled with actions showing an intent to maintain or even utilize that capacity. So consider this as you move forward. If a break stick clearly proves preparation for uncontrollable conflict, what other common tools or training methods or even online searches might a prosecutor successfully argue constitute subjective knowledge of an extreme risk sufficient to turn a tragic accident into a criminal act? Go explore where that line between reasonable preparedness and criminal intent really lies.